Florida probate lawyers, affirmative defenses, probate litigation, and a motion for summary judgment. Hello, my name is John P.L.L.C. I'm a Florida probate lawyer working at the P.L.L.C. law firm in West Palm Beach, Florida. Our firm handles appeals, trials, and disputes involving wills, trusts, estates, guardianships, real estate, life insurance, and related commercial and business litigation. I'm going to be speaking to you now about affirmative defenses and whether you may obtain summary judgment on those affirmative defenses if you're in the middle of an estate lawsuit or a probate lawsuit here in Florida. Now, everybody knows that summary judgment is one of the most appealed issues in Florida's District Court of Appeals. But we also know that affirmative defenses should be raised when answering a complaint. So if you're in the middle of a will contest and you are participating as a defendant or a respondent to a will contest, you should raise any affirmative defenses that may be applicable. Now, in probate proceedings, the rules of civil procedure can apply, including the rules for summary judgment. That occurs when the proceeding is adversary. And whether a probate proceeding such as a will contest is adversary or not depends on the Florida probate rules and whether the proceeding is adversary by its own definition, or whether somebody files a notice that a proceeding is adversary. But assuming that the Florida rules of civil procedure apply in the estate lawsuit in Florida or the probate litigation, let's talk about affirmative defenses. Affirmative defenses, what probate lawyers should know about affirmative defenses is that they're a yeah, but defense. An affirmative defense is not a denial. An affirmative defense is assuming those facts that you allege in the complaint or the petition are correct and true, I've got an excuse why I shouldn't be found liable or responsible. That's a true affirmative defense. Now, fraud in Florida must be pled with particularity. You're required to plead fraud by demonstrating some specifics about the fraud. Where did it occur? By what means? How did it occur? Who may have been involved in the fraud? Undue influence in Florida is a species of fraud, and that also needs to be pled with particularity. So if there's an affirmative defense that hints at fraud or hints at undue influence, that affirmative defense also needs to be pled with particularity. But if I'm in the middle of an estate lawsuit in Florida, can I get a motion for summary judgment granted on affirmative defenses? And if anybody wants to read more about that, they can look at the Gorel case, G-O-R-E-L. It's a December 19th, 2014 case from Florida's 5th District Court of Appeal. It is not a probate case, but it looks at affirmative defenses in the nature of summary judgment. Probate lawyers and those who handle estate trials in Florida know that summary judgment is only granted if there's no disputed material fact, there are no disputed material facts, and the moving party is entitled to judgment as a matter of law. So, can you get summary judgment granted in Florida for affirmative defenses? You can, and this case does consider those matters, and it cites a handful of cases that may be helpful to you in your estate litigation lawsuit if you're faced with affirmative defenses that you believe are undisputed and to which you're entitled to judgment as a matter of law. But understand that the plaintiff must either disprove those defenses by evidence or establish their legal insufficiency to get summary judgment on those. So a court cannot grant summary judgment where a defendant asserts legally sufficient affirmative defenses that have not been rebutted. So you're going to need something to rebut those affirmative defenses to win on a summary judgment motion in your trust lawsuit or your tortious interference with an inheritance lawsuit here in Florida. So you can use requests for admissions, you can use responses to interrogatories, and you can also use allegations that somebody has made in a pleading. Allegations that are made in a complaint or an answer are accepted as true and do not require proof at trial. So we need to be very careful about what we're pleading in a petition or a complaint. And we also need to be mindful in our defense practice that if the plaintiff or petitioner has alleged something in their complaint, that does not require proof at trial. My name is John P.L.L.C. and this concludes my thoughts on the probate litigation topic of can you get a summary judgment ruling on affirmative defenses.